piece of legislation in human services, so I appreciate your indulgence. Before we get started with Senator Steinberg's bill, I want to mention that item number 2 on our agenda has been pulled, and that we have consent items numbers 3, 4, 9, 15, and 18 on our agenda. And in the absence of a quorum, we will begin as a subcommittee, and we will start the afternoon off with item number 14, SB 652, Senator Steinberg. Welcome.
Thank you very much, Madam Chair and members of the committee. Appreciate you taking me at the beginning of the hearing, and I will try to be brief. All of us as legislative authors say our bill is a simple and fair bill. My bill is a simple and fair bill. It prohibits a professional sports team from entering into an agreement to relocate from its home community in California to another community in this state if that team has not satisfied its outstanding financial obligations to its home community. We all know that professional sports is big business these days. We know that there are issues regarding arenas, stadiums, headquarters, and proposed facilities. Communities, of course, are free to decide whether or not to enter into partnerships with professional sports franchises to subsidize the cost of facilities that may be needed to attract and retain teams. And certainly the teams themselves, within limits, have the right to locate or relocate where they deem their best business opportunities. The bill here does not prohibit such partnerships between professional sports teams and local governments. The bill recognizes that such decisions are for local governments, and again in some instances the private business owner, to make. But once a partnership is in fact reached between a community and a team, it imposes reciprocal responsibilities on both parties, just like any other contract. This bill is intended to ensure that any sports team honor their financial commitments to their home communities, pursuant to the agreements they have entered into with their public business partners. Now, this is public policy that I propose for the state of California. But it is no secret that the impetus for the bill was the proposed or potential relocation of the Sacramento Kings from Sacramento to Anaheim. And we all know the history, at least most of us know the history, that in 1997, the city entered into a series of agreements for the purpose of refinancing the Kings' debt on Arco Arena. The refinancing was done at the request of the then Kings ownership, and had it not been done, and I was a member of the city council at the time, had it not been done, the Kings may have been compelled to relocate from Sacramento. Under the agreements, the team covenanted not to relocate to another city until the bonds were paid in full. The entire amount of the debt is $77 million. It becomes due and payable under the contract by the Kings immediately if the team signs a relocation agreement. Now, the current owners of the Kings have always paid their debts, and they have been good stewards. It's not really about them. But if anyone is seeking to make a cold business decision about where they want to locate, the public policy in California ought to be that the city from which they consider leaving is made whole before they in fact do leave. Yes, this is about the Kings and about professional sports, but it's about, really what it's about, are the city's libraries and parks and police services and fire services, especially during this difficult budget time. Cities cannot be left holding the bag. So specifically, the bill does the following. It prohibits a team from entering into a relocation agreement if it has entered into a financial agreement with the local community in which the team currently resides. Unless the team posts a bond to the local community with whom it has the financial agreement in an amount adequate to ensure all obligations of the team under the financial agreement that they will in fact be satisfied. It prohibits the team from entering into a relocation agreement if the agreement puts the team in breach or default of any financial agreement it has with the home community until the default is cleared. It also declares such a relocation agreement, if there is such a breach, to be contrary to public policy and unenforceable, and gives the home community the ability to seek injunctive relief. The bill is, I think, best summed up by the very fine committee analysis. It's simply, the bill does not prevent a professional sports team from relocating. It simply requires the team to pay its debts and obligation before it does relocate. Now, hopefully, in the instance that precipitated this bill, there won't be a relocation. That's certainly my hope. But sometimes specific fact situations lead to the appropriate consideration of statewide public policy, and this is such an instance. I know I'm joined here by Eileen Teichert, who's the city attorney from the city of Sacramento, and John Dangberg, who's the assistant city manager from the city. You can answer any questions about anything, any specific facts, but I'm prepared to answer the committee's questions as well. Thank you very much.
Excellent. Thank you, Senator Steinberg. Before we go to witnesses, we have a quorum, so clerk will call the roll.
Evans?
Here.
Evans here. Harmon? Here. Harmon here. Blakesley? Corbett? Here. Corbett here. Leno? Here. Leno here.
Any questions of the author before we go to witnesses? Yes, Mr. Harmon.
Senator Steinberg, could you please, or maybe you'd rather wait until legal counsel comes up, but I'm interested in your view on the impairment clause of the Constitution, sure, which, as you well know as an attorney yourself, that government cannot impair the rights of parties to a contract. And does this bill run afoul of that prohibition?
I do not believe it does. And again, Senator Harmon, the analysis, I think, lays out clearly the point and counterpoint, but let me tell you why I believe it does not. Number one, again, this is intended to be statewide policy, although it potentially applicable to a current situation. If there were a relocation agreement that were signed before this bill became law, I believe the impairment argument would be defeated because the signator to the relocation agreement would be signing that agreement with full knowledge of this, the debt, first of all, that was owed to the first city, and second, the existence of this legislation, which is moving through the process itself. Secondly, even if the threshold test for impairment could be met by a plaintiff, I think it would be ultimately defeated because the constitutional analysis allows the public entity to essentially demonstrate that they have an overriding interest in going forward with the legislation. And in this instance, the overriding interest is protecting the public treasury of any municipality so affected that would have to bear the cost, if you will, at great sacrifice to their citizenry, police service, fire service, parks, etc., if, in fact, the debt is not paid. So I think under both arguments that an impairment argument would be defeated.
I think also, rather than this doesn't impair an agreement, but it provides a tool for the enforcement of an agreement.
That's correct.
And in addition
That's
to the
what I meant to
overriding public. Of course you did. That's why I'm laying it out there. Yes, Senator Corbett.
Thank you very much, Madam Chair. Senator Steinberg, I just wanted, it appears to me what you're trying to do is just make sure that we have some basic fairness, that there was some understandings, agreements that were entered into between the community and this particular team. So I was hoping you could sort of talk a little bit about, why are you seeking this fairness? What is the impact overall to the people that you represent?
Again, I want to be fair to the owners here in this particular instance because they have paid their debts on time. And so, however, professional sports, and I'm a big fan, is cold business. It's what it is. And if there is a threat to any city losing this sort of an asset, that's one thing, and we're fighting that on other fronts. But if a city loses that asset, and they're also left with tens of millions of dollars of unpaid debt, because things sometimes happen in business, that's not a fair result and is contrary to public policy. And this bill seeks to make sure that my city, any city, does not have to go through its budget process over the next year or two and wonder and worry whether or not they're going to have to cut fire stations, cut back on parks and recreation, and cut back on other essential municipal services. Protection.
Senator Steinberg, there were amendments that were proposed. Are you taking those amendments?
Yes.
Okay.
Yes.
Great. Let's go. Pardon?
I have a second follow-up question.
Is it okay if we go to the witnesses and then we'll circle back and ask for additional questions? Okay. Let's go to the witnesses and then we will come back for questions and comments. Witnesses in support, please.
Is she going? I think Ms. Teichert is here to help answer questions that I can't.
I don't know that there are any questions that you can't answer, Mr. President Pro Tem, but I am here to answer any questions that the committee may have. My name is Eileen Teichert. I am the Sacramento City Attorney, and it's a pleasure to be here before all of you today.
Thank you. Other witnesses.
Okay. Good afternoon. My name is Michael Ross. I'm with the California Alliance for Consumer Protection. For the last 30 years or so, we've been running around the Capitol talking to people, legislators, staff, about what's going on in professional sports. In fact, I do remember speaking to Darrell a few times when he was in city council. One of the things that's really interesting here is the scope of what's being affected, and this legislature has done very little to protect us as consumers. Right now, the Dodgers have problems, the 49ers have problems, the Raiders have problems, the A's, the Padres, the Chargers, and of course the Kings. What's interesting about this is we only have 14 professional sports teams, and that was 7 teams, half of our teams. We are the largest sports state, not just in the nation, but in the world. We produce billions of dollars in revenue, whether it be direct or indirect revenue. This bill is a good bill because it's a start in protecting our investment as consumers. Everywhere in this state, we're building something, whether it be an arena or a stadium where we're discussing it. In fact, Santa Clara is one of the proposed places for either the 49ers or the Raiders, and the stadium there is estimated to be over $900 million. One of the catches is that the Raiders and the 49ers don't want to sign long-term leases to stay in that facility. Well, if the facility is supposed to last 25 or 30 years, we should make sure that our investment comes back over 25 or 30 years, not 2 or 3. This is a good bill. I think Mr. Steinberg has done a good job. Thank you, Darrell, for that. We ask for your aye vote. Please vote yes on this.
Pushing the wrong button. Other witnesses in support? Any witnesses in opposition? Senator Corbett?
Madam Chair, I'd like to move this bill.
Okay, and I know that Mr. Harmon, you had a question.
Yeah, looking at the committee analysis, you don't have to look at, but it says that it prohibits a team from entering into a relocation agreement if that team is in breach or default of any financial agreement. Well, as you know, what's breach of contract? How are parties going to know? And it would seem to me that it would be a fertile ground for a frivolous lawsuit to be filed and delay a team that is trying to, in good faith, move and then finally get through the trial court. Then you go to the appellate court. It could be years of delay. In the meantime, the franchise that wants to relocate is losing perhaps millions of dollars a year, is commonly the case. What are we going to do in that situation where someone really does in good faith want to move, but there's a lawsuit that's filed that holds it up for years and years? It seems unfair to me.
Well, if you look, Senator Harman, at least around the country, teams that have sought to leave and relocate, they do it. And a frivolous lawsuit, I suppose, could always be filed, but hopefully something frivolous would be thrown out right away. In this instance, for example, the definition of breach would be very clear. Either the team signs the relocation agreement and is committed legally to pay off the debt in its entirety, or it isn't. And if it isn't and it doesn't, then that's an arguable breach. And certainly the contract is very, very clear. $77 million due and payable upon a relocation.
Okay.
Senator Leno.
Thank you, Madam Chair. I think I'm the only non-lawyer among us, so thank you for letting me be part of this conversation. But I would think that the answer to Senator Harman's question is cure the problem. And your legislation just says that when there is that identified debt, in this case it is a $77 million, they just have to give Sacramento a bond undertaking or deposit in an amount adequate to ensure that all of its obligations will be satisfied. Simple as that. Case goes away, you can move. But you just, as the chair said, have to be held true to an agreement. That's all we're trying to do here. So I just wanted to ask, we've all expounded upon the wisdom of this piece of legislation. Given this is not a novel situation and we have municipalities tugging at sport teams to draw them from one location to others as an ongoing phenomenon, has this kind of legislation been attempted or put into place anywhere else?
I don't know the answer to that question. No, not that we know of. Yeah, if you were looking for any kind of a counterpart, if you remember a number of years ago, Senator Torlakson, now the Superintendent of Public Instruction, authored legislation that created a fiscal disincentive for one city to lure, if you will, a big box store from one side of the boundary and border to another. And that's comparable here. You know, it might be a different situation if we were talking about a California city and a city outside of California. But when we're talking about California, we're one state, we're many cities and many counties, and if there is such a relocation, again, the first city should not be left holding the bag.
There would appear to be some irony in this whole story in that it was the Kings themselves who requested this refinancing to be able to keep them in Sacramento.
A prior owner, yes.
Yeah.
Yeah, no, that's very true. It was a very memorable chapter of recent Sacramento history that I was part of, and it was very controversial. But the assurance always was that the debt would be paid off, and that's all we're seeking to make sure is reflected in our public policy.
Very good. Thank you.
Okay. Senator Steinberg, would you like to close?
I think it's been a terrific discussion. I'm very appreciative, Madam Chair, and your consultant again, Ms. Kim, did a great job, and members of the committee, thank you very much. I'd urge an aye vote.
All right, we have a motion. Clerk will call the roll.
The motion is do pass as amended to the Senate floor. Evans?
Aye.
Evans, aye. Harmon?
No.
Harmon, no. Blakesley? Corbett? Corbett, aye. Leno? Leno, aye.
Three, two, one. The bill is out.
Thank you very much, Madam Chair
Thank
and
you,
members.
Senator
Appreciate
Steinberg.
it.
All right, next. And before we go on to our next author, which will be Senator Calderon, I was remiss in making a statement at the outset. The committee has a number of bills to hear, a number of witnesses to hear from, and so I would be appreciative if the authors and the witnesses could be as expeditious as possible in their statements and in their testimony. I don't have a hard and fast rule of 2 minutes per side, but I will try to ask witnesses to limit their testimony to 2 minutes and no more than that, and I'll let you know when that time is up so that we can do due consideration to all of the bills on our agenda today. Senator Calderon, you have items number 1 and 16 on our agenda. We'll start with item number 1, SB number 4. Oh. Go right ahead.
Where are you? Just one moment. Just need my staff to bring me my notes. If you could just give me a moment, or if we could start on
with item number 16.
We could do that.
Sure, let's do that.
Great, thanks. Can we go back to the first one? Sorry.
All right, just to be clear, we're starting with item number 1, SB4.
SB4.
My staff is running it back and forth. Okay, I think we're all in place now.
Yes. Thank you.
You may begin.
Thank you, Madam Chair. Members, SB4 adds 2 informative notices to the notice of sale, one intended to help property owners and the other intended to help bidders. It's unfortunate but very common for homeowners going through foreclosure to be surprised by the knock on the door telling them that their house has been sold and giving them a short period of time in which to move out. Homeowners don't understand that the sale date listed on their notice of sale could change. And when the date on their notice of sale comes and goes and no one asks them to leave their house, well, they think they're safe. They don't understand that their sale date has simply been postponed, and nor do they know how to find out when their sale date has been rescheduled. One of the 2 informative notices added by SB4 provides homeowners with information about sale postponements. We can't save every home from foreclosure, but we can give information to homeowners which they can then use to avoid nasty surprises from people knocking at their door demanding that they move out. We are also starting to hear from bidders who are surprised to learn that they have purchased second liens at foreclosure sales as opposed to bidding on a purchase of a home. Now, unsophisticated bidders think, as I said, they think they're buying a house on the courthouse steps. They don't understand that they're just purchasing a lien position and will have to pay off all the liens senior to the one they are purchasing in order to get clear title to the property. The second informative notice added by SB4 warns bidders about some of the risks of bidding and gives them information that they can use to better protect themselves if they choose to bid. SB4 is supported by the United Trustees Association and the California Bankers Association. I have Mike Belote and Kevin Gould also here testify in support of the bill.
Thank you very much. Mr. Belote.
Madam Chair and members, Mike Belote for the United Trustees Association. Trustees are the folks who conduct non-judicial foreclosures under the Civil Code. What the bill does is put notices in the law that will explain to bidders the risks of bidding and explain to homeowners how best to track their foreclosure. What it will also do is require something that's never been in the law before, and that is either a 24-hour internet site or a phone line for homeowners to call and find out if their sale has been postponed and what the new sale date is. It's not an obligation that's in the law now. We support the bill because it's, frankly, a service that homeowners ought to have. The actual Postponement is cried on the courthouse steps, but it's fair to tell people when to expect the process to end. No one likes the foreclosure process. It's a fact of financial life. So we would ask for an aye vote.
Thank you. Next witness. Any other witnesses in support? Any witnesses in opposition? This is, in the words of Senator Steinberg, a simple and fair bill.
Seems to be.
Questions, comments from the committee members? All right. Do I have a motion? Senator Leno has moved the bill. Would you like to close?
Ask for an aye vote.
All right. Call the roll.
The motion is due. Pass to the Senate floor. Evans?
Aye.
Evans, aye. Harmon? Harmon, aye. Blakesley? Corbett? Corbett, aye. Leno? Leno, aye.
Thank you.
Apparently, Mr. Blakesley is absent for the time being, so that bill has 4 votes, but we'll leave the roll open for Mr. Blakesley to add on. Yeah. All right. Item number 16, Senator Calderon.
Thank you, Madam Chair. And this is even a simpler bill. Members, SB 712 is a Department of Insurance bill that safeguards to safeguard its continued accreditation. For over 100 years, our national system of state-based insurance regulations been built on the joint work of the nation's 50 insurance regulators. They work together via the National Association of Insurance Commissioners, or the NAIC, that is widely known. A little-known fact about the NAIC is that it administers a national program or insurance department accreditation. The NAIC's Financial Regulation Standards and Accreditation Program, as it's called, identifies 18 laws critical to solvency oversight, also for accreditation, and identifies insurance departments must have all 18 in place. Senate Bill 712 adds to state law key parts of the NAIC property and casualty actuarial opinion model that the DOI requires for accreditation. The Senate Insurance Committee is sponsored by the California DOI, and it is here to speak in support. Committee staff has suggested amendments in the analysis, which I accept as author's amendments. I ask for your aye vote for this simple piece of legislation.
Thank you. Witnesses in support.
Yes, hi, good afternoon. Michael Martinez, Deputy Commissioner and Legislative Director for the California Department of Insurance. I'm here with Ron Dahlquist, our Chief Actuary with the Department, to answer any questions. And for purposes of time, considering I believe that there is no known opposition to this measure, that we do believe that this bill is needed to preserve the Department's NAIC accreditation status. And so we ask for your aye vote in support of this bill. Thank you.
Thank you. Any other witnesses in support of the bill? Any witnesses wishing to speak in opposition to the bill? Okay, we have a motion. Any questions or comments from the committee? All right, Clerk, would you like to close?
Yeah, I appreciate the robust debate that's gone on over this, and ask for your aye vote.
Again, a fair and simple bill. We like those.
I'm ready.
We'll have plenty of debate later on other bills. Clerk will call the roll.
The motion is due. Pass as amended to the Senate Appropriations Committee. Evans?
Aye.
Evans, aye. Harmon? Harmon, aye. Blakesley? Corbett? Corbett, aye. Leno? Leno, aye.
4-0, the measure will be on call for Mr. Blakesley to add on.
Thank you, members.
Our next author in file order would be Mr. Correa. Is Mr. Correa in the room? He is not. Mr. Padilla. Senator Padilla? Items, let's see, we have item number 7 as well as item 11 and 13. We'll start with number 7, SB 332. Go ahead, Senator.
I believe this is item number 7, SB 559. Is that correct? Just want to make sure we're on the right bill.
I'm sorry, I have 332.
332,
item number
okay.
7.
Let me just skip to that presentation here. Okay. Thank you very much, Madam Chair, members of the committee. As many of you know, I've shared this both in committee settings as well as privately. I've been working to reduce tobacco use and exposure to secondhand smoke and even accessibility of tobacco to minors for many, many years, beginning on during the time I served on the Los Angeles City Council. And part of the state's comprehensive policy strategy to reduce tobacco use and the consequences of secondhand smoke is to support smoke-free spaces in the workplace, in recreational areas, and other public spaces. And I believe it's important to support landlords who choose to create healthy living environments for their tenants as part of our comprehensive strategy. I won't reiterate the years of research that you're all well aware of, acknowledged by the California Air Resources Board, where secondhand smoke is considered a toxic air contaminant, the U.S. EPA's classification of secondhand smoke as a carcinogen, et cetera, et cetera. But I will cite that the Centers for Disease Control and Prevention believe that secondhand smoke is responsible for nearly 50,000 deaths each year in the United States, which include 3,400 lung cancer deaths and 46,000 deaths due to heart disease. So despite knowing the health effects and consequences of tobacco use, current law in California is silent as it pertains to a landlord's ability to restrict smoking in rental housing settings. Meanwhile, over 30% of California's housing is multi-unit residential, such as apartments and condominiums. Secondhand smoke travels in and out of open windows and doors through shared ventilation systems inside walls, ceiling crawl spaces, and gaps to run electrical wiring, light fixtures, etc. What this bill does is it clarifies in current law that a rental property owner can make individual units, if not a whole complex, smoke-free. As referenced in your analysis, I do take as authors' amendments those suggested that delete the first line, notwithstanding any other provision of law, that change Civil Code 1162 to 827, those that include federal to state and local requirements, deleting the word notice in line 32, and adding the quote lease or end quote before rental agreements, and the following clarifying amendment on page 3, line 34, after the period, to insert sort of a new clause, again, as referenced in the analysis. So with that, I would ask for your support and introduce Jennifer Snyder of the American Diabetes Association and Shantna Pakin of the California Apartment Association.
Senator Padilla, I want to clarify the amendments that we, as a committee, were asking you to take. They're actually on page 6, and they're clarifying amendments. Page 6 of the staff analysis.
My apologies.
It's okay. Just want to be clear about what amendments you'll be taking in this committee. Okay, you said you had witness in support? Witnesses in support of the bill?
They're out there somewhere.
Witnesses in support of the bill. SB 332, a fair and simple bill. All right. Witnesses in opposition to the bill.
Madam Chair, excuse me, Ron Kingston, representing the Apartment Association, California Southern Cities, San Francisco Association of Realtors, and the Rental Property Owners of Northern Alameda County. We have presented 2 amendments to your staff and to the author. They have graciously agreed to those amendments. Mr. Padilla is committed to put the amendments before the bill is going to be heard in Judiciary Committee in the opposite House. The 2 amendments are as follows. 1, we want to make sure that it doesn't affect any other term or condition of the contract, so the limitation or prohibition of smoking, or that it doesn't affect any other term or condition. Second is that we have observed with the senator to assure that we don't have to continue coming back to the legislature to receive, in a sense, permission to do what we contractually already can do today. So, in pertinent part, our language reads, this article, which Mr. Padilla creates, does not require statutory authority to establish or enforce any other lawful term or condition of tenancy. With those 2 amendments, when they go in the bill, we will formally remove our opposition. Sorry for the voice, but
it's allergy
that's the
season.
time
it
of year.
Happens to me too.
Might be a good thing for some.
Not for lobbyists or committee chairs.
Madam
Yes,
Chair,
sir.
members, Sean Smock, representing the Apartment Association of Orange County. We are part and parcel of the two amendments that we've suggested. There also are a couple of technical amendments. The bill in print refers to 1162 of the CCP. It should be 827 of the Civil Code, and I think those amendments are acceptable to the author. So if the author commits to those amendments before heard in the other House, we're satisfied with the bill.
I appreciate everybody's willingness to work on these amendments. Unfortunately, we didn't get them until Friday, I believe, and so the committee staff has been unable to analyze them, so that's why I'm not asking you to take them in committee at this point, because we haven't even had a chance to fully analyze them. So I'd appreciate it if you could keep us in the loop as you negotiate this and reach some final amendments.
Absolutely.
Okay. Any other witnesses in opposition? Questions or comments from the committees? Senator Corbett?
Just a question on the authors, but these were amendments that looked good to you, were agreeable to after you took a look at them.
Yes, I guess technically they're still opposed, but what they've suggested seem acceptable at first blush. We want to work with committee staff as well as other stakeholders just to make sure that there's not something that we're missing, but it's my full expectation that when the bill reaches the other House, we can amend it there and have smooth sailing.
Ms. Corbett, to help you along, we've also vetted this with Christine Minahan. She has signed off on it, and we presented these amendments to the author a couple of weeks ago as we worked through the process. These weren't brand new. And we've had the time to speak with Mr. Palmer about them as well, so we have conducted our due diligence.
I'd be glad to move the bill if there's no other questions.
Thank you.
And also on the issue of the amendments, conceptually they look good to us, but we need to analyze them thoroughly and make sure we're not creating some additional problem. I just want to mention, when I read the bill, I agree with you, Senator Padilla. I dislike smoking in areas that can affect people who do not wish to smoke, and I appreciate the regulation. I also think as a practical matter, landlords will hopefully be able to set aside some place, and that'll be part of the lease as we go forward, and they'll be able to deal with this in a more practical way than the legislature can. And so I think it's a good bill, and it's targeted towards a very important problem I think we need to deal with. Did you have any close?
The only thing I would add is, part of what's kept me pursuing this concept, because this isn't the first time I proposed a bill with this intent, is really a social justice concern and consideration. If you have the means to buy a single-family home, regardless of the size of the lot, you can choose to live in a smoke-free environment or not. There's millions of Californians who don't have that luxury. And I believe a lot of parents out there who would do anything they could to make sure their kids are living in a smoke-free environment, and they deserve those same opportunities. Ask for your aye vote.
All right. Did we have a motion? Yeah. Senator Corbett has moved the bill. Please call the roll.
The motion is to pass as amended to the Senate floor. Evans?
Aye.
Evans, aye. Harmon? Harmon, aye. Blakesley? Corbett? Aye. Corbett, aye. Leno? Leno, aye.
The bill has 4 aye votes. Again, we'll leave the roll open for Senator Blakesley to add on later.
Thank you.
We can now proceed to your next item, number 11, SB 559.
Thank you very much. Members, the bill before you, SB 559, also known as the California Genetic Information Non-Discrimination Act, would add genetic information to the existing list of protected classes in California laws that are in the Unruh Civil Rights Act and the California Fair Employment and Housing Act. As many people are increasingly aware, genetic testing can allow individuals to take steps to reduce their likelihood of developing a number of disorders. And in fact, new knowledge about genetics can allow for the development of better therapies and more effective treatments against disease. And there's significant potential for medical progress given genetic research that's happening. But if we look back at the history of genetics, we are reminded that the early genetic research and thinking was also the basis of state laws that provided for the sterilization of persons having presumed genetic defects such as mental retardation, mental disease, epilepsy, blindness, hearing loss, among others. The first sterilization law was enacted in the state of Indiana in 1907. California followed suit just 2 years later. 30 states ultimately enacted such laws that resulted in 64,000 mostly poor young women being sterilized. Shamefully, nearly a third of the sterilizations took place in California. I don't want to speak for too much in this dark chapter of California and national history, but I wanted to prove the point that for as much promise as genetics and genetic research pose for medicine, there are clearly reasons to make sure that we don't abuse the information and knowledge that comes with that research. We can talk about sickle cell anemia in African Americans and policies that this state included. A number of states acted on in that time period. We can look to a legal case, Norman Bloodsaw versus Lawrence Berkeley Laboratory, where genetic information was used to discriminate in the workplace. The federal government has moved forward with what's known as GINA, the Genetic Information Non-Discrimination Act, that covers this issue on a federal level, but in my opinion, not in a complete way. California civil rights protection laws covers more categories than our federal government does. So this bill is before us to make sure that in California, the protection against discrimination based on genetic information is complete, as we in Californians do deem it. That's what the bill does before you. Let me introduce Jim Gross here to testify in support.
Jim Gross with the law firm of Nielsen Merksmer. I have worked with Senator Padilla for the last 2.5 years on behalf of a genetic testing company, and I've also worked with the staff of this committee and with the former chair of this committee. And the goal that my client has had is to expand the database of information that would allow for meaningful use of genetic information in the medical area. In doing that, we discovered grave concerns that in many ways are very valid about not only the privacy, but how in fact do you control the information to ensure that it is not used incorrectly. And despite all this support for developing this genetic information, until such time as we establish a clear protection in law, there will be both practical and legal impediments to developing that information. That information is so valuable to the future of medicine. But if, in fact, the risk of it being misused remains as high as it may be now, then we are not going to see the full development of that information. It's not just an economic issue. It clearly is a scientific and medical issue, and that is why I'm here supporting the bill.
Thank you. Other witnesses in support?
Janice Norman, on behalf of the American Federation of State, County, Municipal Employees, for the reasons earlier stated, we're in support of the bill as well.
Thank you.
Mario Guerrero, on behalf of Equality California, in support.
Any other witnesses in support of the bill? Any witnesses in opposition to the bill? And we've received no opposition. Questions, comments from the committee members? All right, the bill has been moved. Would you like to close?
Just one final thing before asking for your vote, and that's just to reiterate that I, too, believe in the promise of better therapies, cures for diseases that have so far eluded us based on genetic research that's taken place. By letting the public know that this information will not fall into the wrong hands nor be abused, I think will have given people the confidence and the comfort level to participate, whether it's in university-based studies, other public sector studies, or even help the private industry further along. But we need to have confidence in the protection of information and that it won't be abused, and I think this bill is a step in that direction.
This is another bill where technology has outstripped California law's ability to protect its citizens, and I think it's a good bill. So we have a motion. Would you call the roll, please?
The motion is due. Pass to Senate Appropriations Committee. Evans?
Aye.
Evans, aye. Harmon? Blakesley? Corbett? Leno? Leno, aye.
The bill has 2 aye votes, 3 members are absent. We'll leave the roll open. All right, Senator Padilla, you have item number 13, SB 642.
Thank you very much. Members, just by way of background and context, in 2009, I authored SB 424, which updated California law regulating the franchise relationship between automobile manufacturers and their franchisees. And we did so to provide car dealers with the flexibility to continue to serve their customers and their communities, and by standardizing their franchise agreement with what was pretty much industry standard throughout the country, also on a timely basis acknowledging what was a changing economy. With the help of SB 24 and an economy that is struggling to recover, the California new vehicle market improved in 2010 for the first time in 5 years. And while new vehicle registrations are up in the state by 13%, and we project a similar increase this year, we can't rest on our laurels because even with those improvements, sales levels are still well below the levels recorded prior to the recession. Part of this upward trend, however, I think is because of the protections that SB 424 put in place. Unfortunately, there's new dealer franchise provisions that jeopardize these protections. And specifically, there's dealers being sought by manufacturers that require dealers to waive their rights by signing quote-unquote voluntary agreements, to waive their statutory rights to protest their termination, and other things along those lines. So this bill, SB 642, would prohibit a manufacturer from enforcing any agreement with a dealer that modifies or disclaims any manufacturer obligation or waives dealer rights under California's franchise laws. It would prohibit manufacturers from obtaining or enforcing any agreement that requires a dealer to self-terminate. It would prohibit manufacturers from discriminating against franchise dealers for selling non-approved or sponsored debt cancellation agreements, maintenance plans, and service contracts or similar products. Basically, what I'm pursuing here is continued fairness for both auto manufacturers and dealers, along with an independent review of new vehicle franchise agreements and the prohibition of discrimination of dealers that refuse to enter overtly restrictive agreements. I want to acknowledge that we received some very last-minute opposition by the auto manufacturers, raising some very specific issues that I am confident we can work through, but they came to our attention literally just a day and a half ago, and we didn't have time to try to address them in front of this committee. So similar to one of the previous bills, we'll have to work with your committee staff to craft specific language to address it and keep this committee apprised of those ongoing conversations. With me to testify in support of this bill is Brian Moss on behalf of the New Car Dealers Association, and Skip Dahm on behalf of the California Recreational Vehicle Dealers Association.
Go ahead.
Madam Chair and members, Brian Moss with the California New Car Dealers Association. We're the sponsors of the legislation. I think Senator Padilla adequately set the stage for you in terms of the context of the vehicle market and how difficult it's been. And as you may have seen in the paper today, you know, manufacturers are starting to record profits again. Things are looking up. But the relationship between manufacturers and dealers, although they're business partners, sometimes can become strained when manufacturers use their market advantage to insist upon provisions and agreements that in some cases require dealers to waive their statutory rights. And if you take a look at the franchise system, which has been in place in California for over 40 years, there are detailed prohibitions that are applicable to dealers. There are detailed prohibitions that are applicable to manufacturers. And what the manufacturers have done in the last few years is take advantage of a recent court case, bankruptcies of General Motors and Chrysler, to insist that dealers sign agreements that require them to terminate the agreement without the ability to protest a termination before the new motor vehicle board. That's a right provided in statute. It requires them to waive rights that are provided in Senator Padilla's bill of 2 years ago about the ability to combine facilities if such a combination is reasonable, and similar things. And just to give you a perfect example of what's being required, there hasn't been a new Fiat franchise in California in over 20, 30 years. But in the new Fiat dealer agreement that every dealer is being asked to sign, They're being asked to sign an agreement that terminates on its own terms within 5 years. So the agreement will disappear within 5 years, and a dealer who wants to become a Fiat dealer will have no choice but to waive their right to protest. And to make things even more interesting, the agreement also provides that if, for whatever reason, the dealer gives up the Fiat franchise, they also give up every other Chrysler franchise that they may operate. Dodge, Chrysler, Jeep, Ram would also have to be given up, and they would have no way to protest this before the new Motor Vehicle Board. This is the central tenet of the bill. The bottom line is manufacturers shouldn't be able to make legal in an agreement what is otherwise illegal in California state law. And that's the essence of this bill. We're obviously willing to work with manufacturers to address specific concerns, but we're pretty clear that the waiver provisions are fundamental. Much like the state wouldn't allow employers to waive child labor laws because of the overriding public policy, we shouldn't allow manufacturers to insist that dealers waive their fundamental protest rights. And for that reason, we ask for your aye vote.
Thank you. Other witnesses?
Yes, Madam Chair. Skip Dahm on behalf of the California Recreation Vehicle Dealers in California. Senator Padilla's bill really is a very fair bill and solidifies the protections that are in the law and, in fact, advances them into a public policy that actually can benefit the consumers because it would allow dealerships to become more flexible in the products and services that they render to them. So it's a win-win for dealerships and it's as well as consumers. We urge your aye vote. Thank you.
Mark, seconding with the Association of California Insurance Companies, we represent a number of companies that write service contracts for automobiles. What we run into sometimes is the manufacturer will only allow their service contract to be sold and will not give the dealer the option to sell other service contracts, which might be actually better for the consumer and better for the dealer. This bill would eliminate that prohibition so the dealer could shop for the best service contract for both their customers and themselves. Thank you.
Thank you. Other witnesses in support of the bill? Any witnesses in opposition to the bill? And I will say that we didn't receive opposition until yesterday, which makes it very difficult, as you've heard me say in other bills, makes it very difficult for our staff to analyze the opposition and any proposed amendments. So just with that in mind, go ahead and make your comments. But I do want to mention, hopefully there are ways to deal with the problems, but obviously this committee won't be able to provide that kind of ability in this committee at this point. And the opposition, as I read it, really strikes at the heart of the matter. So I think it's important to hear. Go ahead, Mr. Urban.
Gene Urban on behalf of the Alliance of Automobile Manufacturers. Yes, we were late, for which I apologize. You know, damned if you do, damned if you don't. We were talking to our trusted business partners, the dealers, until as recently as yesterday. But when the conversations were insufficiently promising, we thought we should notify the committee author and others of our opposition. You are correct. We are fundamentally opposed to what we consider the extraordinarily opaque nature of Section 2 of the bill. You issued an admonition at the beginning to be brief. I will try to be brief. I think it destroys notions of finality, settlement, compromise. I listened quite carefully to the distinguished Mr. Moss's testimony. He used the word waiver a lot. Okay, can you pay money to have someone waive something? Is that fair? Between two sophisticated business people to engage in a negotiation and in exchange for consideration agreed to do something or not to do something? The dealers have produced this document that said the case of Williams is critical and is damaging to their interests. And this is the seminal case to which this bill responds. That concerns me because the Williams case involved a waiver that was the result of an arm's-length voluntary transaction in exchange for valuable consideration. At the end of the ruling, the court, in rejecting the dealer's argument, labeled the conduct duplicitous. and said that they were not going to uphold the dealer's right to voluntarily relinquish in return for economic benefit something it now holds. In exchange for money, the dealer agreed not to protest something. Is that what we're after? You can no longer pay somebody money in exchange for something? Is that now illegal under this bill? That's a contract. How do you contract? How do you do an agreement? I don't understand. This is how frustrated we are. The bill to us is very opaque. We don't understand the motivation. If it's to overturn the Williams case, we're troubled. I think we should all be troubled by that. The court ruled the conduct duplicitous. If they're trying to preserve that ability, we have a problem. Lastly, I will note that it applies to contracts entered into before the effective date of the bill. So we signed a contract 2 years ago. On December 31st of this year, we attempt to enforce that contract. Attempt to enforce it. That's legal on December 31st. On January 1st of next year, if we attempt to enforce that contract, we've committed a crime. I don't know what the crime is. Attempt to enforce that which was previously signed and in exchange for which people paid money and agreed not to do stuff. We think the bill is overbroad. Moreover, Madam Chairman, and I'll be a bit presumptuous here, I think you meet next week. I think that serious conversations could ensue this week and that progress could be made. We don't object to their fundamental position if we have market power, and I don't think we do. But if we do, and it's been exercised unfairly, of course I'm not going to defend unfair conduct. But the case is not unfair. The language is not clear, and we're opposed on that basis. Thank you.
Thank you. And I do appreciate your consideration of the committee's calendar, but we are analyzing a number of other bills between now and next week. So, again, I just need to encourage you, if there's some issue that needs to be worked out before the bill comes to hearing in the committee, me and my staff and I are only too willing to help that process along. I really don't like having it brought at the very last minute and then have to deal with it. So, anyway. Next witness.
Madam Chair, members, Bill Doring representing the Motorcycle Industry Council and the Specialty Vehicle Association. And we echo some of Mr. Urban's thoughts there. We think that the contract should be between the manufacturer and the dealer and not within the legislature. Thank you.
Joe Yonka representing Chrysler. We completely associate ourselves with the remarks by the distinguished Mr. Urban. We would like to also add that we were also in conversations with the dealers up until yesterday when they did. In recognition, we assume of the strength of some of our points, put forward some amendments, which we then took a look at and realized were insufficient. And the reason now for our position, we did believe, though, that we did need to make sure that this committee was fully aware of our position, and we will continue to work with the senator and with our friends, the dealers, on this very important topic. But we do believe that we do need to have the right to be able to continue to participate in fair exchange in these regards with our partners. Thank you.
Madam Chair, Dave Ackerman representing Nissan USA. We also are opposed. We registered late opposition. The admonition of the chair is well taken. Appreciate that. We also had discussions through our association with the auto dealers. And satisfactory progress, I don't think, was made so that we could have had a neutral position before the committee, which I would have liked to have been in today. I'm really asking those discussions in this committee facilitate those discussions to move ahead if the bill does go forward. Our concerns really are threefold with the bill, and I'll just mention them briefly. Mr. Urban has mentioned Section 2 of the bill that deals with the voluntary termination agreements. We feel there must be some way to allow a dealer to voluntarily terminate their agreement as long as they aren't under any type of coercion or pressure from the manufacturer. And we think that's important for a dealer to be able to do that. This bill prohibits that. Second, dealing with service contracts. The way I read the bill, if I'm reading it incorrectly, correct me, but it looks like the way the bill is written, it does not allow a manufacturer to require a dealer to provide service contracts through the manufacturer, but dealers still provide service contracts through other third parties. We're not prohibiting, Nissan does not prohibit its dealers to provide those third-party contracts, but we don't think that we should be prohibited either as a manufacturer. The dealer should have the option of providing both. And third, Mr. Urban referenced the retroactivity. That's not an issue, a late issue for this committee. This committee considers bills routinely, and I've never seen this committee enact legislation that violates or renders a current enforceable legal contract invalid at a certain prospective date. So those are the three issues Nissan sees with the bill. Thank you, Madam Chair.
Thank you. Mr. Gonzalez.
Madam Chair and members, Tony Gonzalez, representing the Association of Global Automakers. I want to apologize to Senator Padilla and the committee for our late letter of opposition. It was entirely a function of what we had believed were promising discussions, which didn't bear fruit yet, but I want to thank Brian and the dealers for having made an effort to resolve our concerns before the hearing today. I won't repeat any of the testimony other than to suggest that although we oppose the bill now, we look forward to working with the author of the committee and the sponsor to resolve our concerns. Thank you.
Any other opposition to the bill? And again, I just want to reiterate, having late opposition that strikes at the very heart of the bill before the committee, without the committee having been involved at all in trying to help either neutralize or address some of the concerns, puts the committee in a very awkward place. And I'm not chairing the committee just for the pleasure of moving bills through the committee. I'm chairing the committee, and the committee members are on the committee to help the process through and get to a resolution. Now, we may get to a point of neutrality, we may all sing kumbaya, or we may end up having to, say one side wins and the other loses going out the door. But I really believe that this committee is one in which a lot of these issues can be resolved prior to the time the committee is required to vote on it. And that's what I want everybody to understand, because this is now the second time we've had bills with very late opposition that the committee has not been able to analyze. And frankly, it puts me as a committee chair in a really difficult position. And I've worked with a lot of you lobbyists on a lot of other issues, and really don't like you being in this position, me being in this position, my committee members being in this position, and the staff. So please, if you've got concerns that are, well, and the author as well, yes, thank you. If you've got concerns that are in the process of being resolved, at least let us know so that we're not hit with late opposition the day before the committee hearing. I'd really appreciate that. Are there witnesses against the bill? Anybody willing to speak up? Questions or comments from the members? I don't want to go on a tirade. I just, this is only the second or third committee hearing I've chaired, so I want people to know how I operate. Yes, Mr. Leno.
Just to have the proponents have an opportunity to respond to what the opposition has just told us.
Thank you, Senator Leno. I appreciate the opportunity. I think as evidenced by the number of folks who came up and testified, there is a disparity in market power. That's why all 50 states have franchise laws, to make sure that this important industry is sufficiently regulated and consumers are protected. That is, after all, at the end of the day, what this is all about. If a dealer goes out of business because of unfair treatment of a manufacturer, it's not just the dealer who's hurt, it's the community that's hurt, because they may not be able to purchase or service their vehicles in that community. The fundamental difference of opinion with the manufacturers has to do with their desire to require dealers to waive their right to file protests before the new Motor Vehicle Board, and Senator Padilla's desire in this legislation to say that that is not a waivable statutory right. A dealer should have the opportunity to have a death row appeal, if you will, before a neutral arbiter, so that they can go make the case that, notwithstanding the fact that a manufacturer may have offered them some financial consideration to build a building or to enter into some agreement, that circumstances have changed so dramatically over time that this neutral arbiter could decide that the dealer can remain in business. Make no mistake, 90+% of cases that go before the new Motor Vehicle Board where a dealer is protesting termination, the dealer loses those cases. It would take extraordinary circumstances, particularly in light of a contractual provision where they got a bunch of money to do something and they didn't do it, for a dealer to win. All we want is that last chance to make a case before somebody. That's what the bill does. We are perfectly willing, with the Senator's cooperation and help, to work with the manufacturers to narrow the scope of the bill if it's overbroad. But we are not willing to assuage their desire to continue to insert provisions in every agreement with dealers so that their statutory rights disappear. We're afraid, frankly, if provisions like the Fiat dealer agreement that I described earlier are inserted in every future agreement, there will be no need for protests before the new Motor Vehicle Board because there won't be anything left to protest. The dealers will have waved it all away, and they won't have an opportunity to have a neutral arbiter hear those. So we're willing to work with the opposition, but there are some things, frankly, that are fundamental. And if you go through and read the vehicle code, the very section in the bill itself, you can see a list of dozens of prohibitions against the manufacturers that the legislature has added over the years to make sure that the marketplace is fair between the parties. We think these waiver provisions and the other provisions in Senator Padilla's bill only add to that.
And with regard to Mr. Urban's suggestion that you're attempting to overturn Williams.
The Williams case, like many court cases, you can read a court case a number of different ways. We're not going to defend the conduct of the individual dealer in that appellate case, but what concerns us is the proposition that the subdivision G that's crossed out in the bill, if you read the language of the existing statute, there's already a waiver prohibition in statute. What the Williams case said is that requiring a dealer to waive only occurs when there's been coercion. And in the view of the appellate court, what that meant is that manufacturers were free to pay dealers to waive those statutory provisions in any instance. And our concern is that tipped the balance too far. The legislature already said requiring such waivers was prohibited. The appellate court said only if it's coerced is it prohibited. And we think, considering the unfair and unequal bargaining position that manufacturers hold over dealers in many instances, that they can do lots of things well short of coercion to insert these provisions in agreements. So our view is the Williams case set the table for these future agreements. It's not dispositive on what these agreements say, but clearly it started a trend that the manufacturers are only too happy to exploit.
All right, we have a motion. Senator Padilla, you may close.
Respectfully ask for a vote.
All right, we have a motion. Clerk will call the roll, please.
The motion is due. Pass to Senate Appropriations. Evans?
Aye.
Evans, aye. Harmon? Blakesley? Corbett? Corbett, aye. Leno?
Aye.
Leno, aye.
3-0, the bill will be on call.
Thank you very much.
Next, we will have Senator Vargas, item number 5, SB 252.
Whenever you're ready, Senator Vargas.
Thank you very much.
You're here on item 5, SB 252, dealing with public contracts and personal services.
Yes, I am. Thank you very much, Madam Chair. I appreciate it, and I'd like to present to you SB 252. This bill would require a state agency that enters into a privatization subcontractor contract of $100,000 or more to report the Department of General Services regarding those contracts, make the reports available to the public, and require state agencies to submit specific information relating to the use of private contractors as part of the budget process. According to the Department of General Services, in fiscal year 2009-2010, California spent $35 billion on private contracts. However, Much of this multi-billion-dollar expenditure occurs without substantive government oversight, which results in billions of dollars potentially of wasted taxpayers' dollars. SB 252 will ensure
Please close the back door so we can hear the author. Thank you.
Thank you, Madam Chair. SB 252 will ensure increased accountability, oversight, and public transparency. It's important to note that this bill does not prohibit state agencies from entering into private contracts. It only requires information after the contracts have already been awarded. I would respectfully ask for your aye vote. We do have witnesses here in support. Janice Norman from ASME.
Thank you very much, Senator Vargas. Welcome to your witnesses.
Janice Norman, on behalf of the American Federation of State, County, Municipal Employees, we're pleased to have Mr. Vargas author this piece of legislation. We just think that it's a government bill that provides the legislature with the necessary information related to the contracts that state departments are entering into. As you go through the legislative process, there's not an easy apples-to-apples comparison prompt for the legislature. The legislature often looks at total department expenditures, prior year, current year, budget year. It looks at total number of state employees, current year, budget year, prior year. The funds utilized to provide for these privatization contracts are often in the baseline funding. That funding, typically through the subcommittee process, generally goes unscrutinized. And this would allow the legislature to look at the cost of contracts, current year, prior year, and budget year, what that would equate to in terms of employees, current year, prior year, budget year. So the legislature has the information necessary to make analyze and make prudent decisions on with regards to funding. The other thing it does is it makes the information available to the public through the Department of General Services website. We just think those things make sense, as well as providing access under the Public Records Act.
Thank you very much. Additional witnesses?
My name is Stephanie Burry. I'm with SEIU Local 1000. We're a co-sponsor of this legislation, and Local 1000 has been an advocate on behalf of making contracting out more transparent. We've been doing this for years, and we want to make sure that every contract the state has is as transparent as the work that our members do every day in the state budget. So this will make a big effort towards going that way.
Thank you very much for your testimony.
Madam Chair and members, Caitlin Vega for the California Labor Federation here in support. When we are all struggling so hard to find solutions to the budget crisis that we face and having to make such hard and painful cuts, it's pretty shocking to me that we have so little information about where state dollars are going to be able to help us make the right decisions and ensure that we're protecting the most essential services and the most important programs. So we think that this is a very important bill. Thank you.
Thank you very much. Other witnesses in support?
Madam Chairwoman and members of the committee, Willie Pilote, representing the American Federation of State, County, and Municipal Employees. I'm here to answer any technical questions that may come up. And I read the opposition point of view in the analysis, and I would like to say just a couple of things, is that this is really about transparent government. It's really about when taxpayer dollars are being used, that the public should have access to information. The legislature should have access to the information, and we truly should just basically make sure that the way that the dollars are used, that is something that we can all see on a day-to-day basis, and we ask for your strong support of the bill.
Thank you very much. Other witnesses in support?
Madam Chair, members of the committee, Shane Gussman on behalf of the Teamsters, United Food and Commercial Workers, Unite Here, and the Amalgamated Transit Union in support.
Thank you very much.
Madam Chair, members of the committee, Lee Sandall with the International Longshore and Warehouse Union. And this is an exceptionally strong piece of legislation requiring much needed transparency on outsourcing. Anyway, we are in support.
Thank you very much. Next.
Madam Chair, members, Deanna Furman on behalf of the California Nurses Association. Just want to thank the author for introducing this bill. In light of the attacks we've seen on public employees around the nation, it's nice to have this piece of legislation before us.
Thank you very much. Any other witnesses in support? We have a question. Senator Leno.
Mr. Pilote, were you referring to some opposition?
I thought I read something in the analysis, but maybe I didn't. I'm hoping that there are none, because we all should be talking about how do we support transparency in our government.
I thought you might be aware of some that I wasn't.
Oh, no, I'm with you.
All right.
Thank you.
Thank you very much. But we'll ask, is there any opposition here to testify? All right, we settle that question. All right, we have a motion. Senator Vargas, would you like to close?
I would just thank you for the time again, and this is a good bill about transparency, I appreciate the time provided for me to present. Thank you very much.
Thank you very much. Please call the roll on the measure.
The motion is due pass to Senate Appropriations Committee. Evans, Harmon, Blakesley, Corbett.
Aye.
Corbett, aye. Leno, aye.
Okay.
Thank you very much.
That bill has 2 votes. It'll be on call. It just needs 1 more vote to pass.
Thank you.
Thank you. Next author, Senator Correa. And you are here on item number 6, SB 264, dealing with recreational activities and skateboard parks.
Skateboard parks, yes.
Whenever you're ready.
Thank you, Madam Chair and Senators. This existing law provides that a qualified immunity to local public agencies that operate public skateboard parks, provided that they meet certain criteria, including requiring persons who skateboard wear helmets, elbow pads, and knee pads. That immunity will sunset in January of 2012. This bill will remove that sunset date and thereby extending the immunity indefinitely.
Thank you very much, Senator Correa. Do you have witnesses in support?
Yes.
Please. Welcome.
Good afternoon, Madam Chair, members. Julianne Broyles here on behalf of the California Association of Joint Powers Authority in support of SB 264. This is a bill that we think is very common sense. It's not a complicated bill. It basically extends a limited immunity to those public entities that I work with who operate the skateboard parks as public operations. Would ask for your aye vote.
Any other witnesses? We're in support?
Yeah.
Any other witnesses in support?
Yeah,
okay.
Really quick.
All right.
Madam Chair and members, Doug Houston, representing the California Park and Recreation Society, sponsors of the bill, and we're urging your support as well. Thanks. Kirk Blackburn on behalf of the city of La Cañada, Flint Ridge, who operate a skateboard park, and are certainly appreciative of the Senator's efforts to extend the immunity. Thank you.
Any other witnesses in support? Any witnesses in opposition? Questions or comments from the committee members? Ms. Corbett?
I don't have any questions, but I think it's a fine bill. I don't believe it does have opposition, right?
I don't believe so. And let me just clarify that I omitted at the beginning to state that I accept the suggested amendments as the author's amendments.
Glad to move it as amended.
Thank you.
All right. Would you like to close?
Ask for an aye vote for all the skateboarders of California.
I did want to mention my son was a skateboarder as a teenager, and I think this is a really good bill. It was
Any broken bones?
No broken bones, no skull fractures, nothing, thank goodness. Can't say that for all of his friends, unfortunately.
That is true.
But the original legislation was very good, and I was happy to see it pass, and I'm happy to see this bill as well.
Thank you very much.
So we have a motion, and clerk will call the roll.
The motion is due pass as amended to Senate Appropriations Committee. Evans?
Aye.
Evans, aye. Harmon? Blakesley? Corbett? Aye. Corbett, aye. Leno, aye.
3-0, the bill will remain on call for the absent members.
Thank you, Madam Chair. Thank you, Senators.
Thank you, Senator. We will start, next we will take Senator Corbett, item number 8, SB 459, item number 4, SB 180, and then we'll go to item, all right. Item number 4 is on consent. We will go to item number 8, SB 459. And then we have, after that, item number 17, SB 823.
I know you were just trying to fake me out there. I know. I think there are some witnesses in support on this measure.
Go right ahead.
Senate Bill 459 is intended to reduce the likelihood that employees will be misclassified as independent contractors. When a worker is misclassified in this way, it affects the way California labor laws, such as minimum wage, overtime protection, workers' compensation coverage, family leave, and unemployment insurance are applied. The misclassification of workers results in a loss of payroll tax revenue and often an increased reliance on state-funded public services, issues we're very concerned about in this economy. It also creates an unfair playing field for responsible employers who honor their lawful obligations to their employees. SB 459 prohibits the willful misclassification of an employee as an independent contractor provides that a consultant who knowingly misadvises an employer is jointly liable if the worker is found not to be an independent contractor, and requires that independent contractors be provided with information about their classification, their tax obligations, and other relevant information, and to be told how to request a determination from the State Employment Development Department to determine if they are correctly classified. According to the General Accounting Office, at least 10 million workers are classified as independent contractors nationally, an increase of more than 2 million in just 6 years. SB 459 provides simple steps to ensure workers are properly classified, and this bill is supported by a long list of people who care about workers' rights: the California Labor Federation, the California Teamsters Public Affairs Council, the Communication Workers of America, District 9, the State Building and Construction Trades Council, the Consumer Attorneys of California, and the California Nurses Association, AFSCME, and many others. And many are here to testify in support today. Ask that you support this bill, members.
Thank you. Witnesses in support.
Madam Chair and members, Caitlin Vega for the California Labor Federation. We are proud to sponsor this bill. Over the past decade, we've seen a real transformation in the nature of work, and increasingly we're seeing workers become contingent labor. So instead of having the traditional employer-employee relationship where a worker works for a company, hopefully for much of their adult life, and is able to retire after a lifetime of service, instead we're seeing workers employed by intermediaries, shuffled from one employer to the next with little job security, and in its most extreme form, misclassified as independent contractors. Once a worker is misclassified as an independent contractor, they lose all rights of a worker. They're not protected by minimum wage laws. They're not protected by Cal OSHA. They don't have the right to organize. They don't have the right to family leave. They don't have the right to maternity leave. So we see this as a very serious threat to our ability to maintain basic labor standards for California workers. What was once isolated in a few industries has spread across industries, and so this is an issue that matters to workers really across industries in California. What we're trying to do in this bill is address employers who are deliberately flouting the law to gain an unfair advantage over their competitors, to get rid of workers' compensation costs, to cut labor costs when they know the law and understand the law. In addition, what we're trying to do is arm workers with information about the law and their rights. Under existing law, oftentimes workers do not understand that they've been misclassified. They don't understand what that means in terms of their rights. And so this would require that when someone contracts with an independent contractor, they have to simply tell them about that about that classification and the basis under law, how that's made, how that's evaluated, and where to get help if they think they've been misclassified. We think that in an era of declining labor law enforcement, it's essential that workers be told their rights and have the opportunity to get help if they have been misclassified. Thank you.
Next witness.
Madam Chair, members of the committee, Shane Gussman on behalf of the California Teamsters Public Affairs Council, the California Conference of Machinists, the Amalgamated Transit Union, Unite Here, and others in strong support of this bill. As the previous witness stated, this bill is really about the bad actors. It goes after intentional misclassification of workers, and it also provides what we believe is the missing piece of this is some information for workers to have so that they will know simply whether or not what it means when they're hired by someone and they're classified as an independent contractor, what that means for them, that they're going to owe both sides of the payroll taxes, that they're not going to get all kinds of different benefits that would happen if they were an employee. And we think this is a well-designed bill to go after a very specific but large problem in our state. We urge your support.
Madam Chair, members, Cesar Diaz on behalf of the State Building and Construction Trades Council, also here in strong support. One of the industries where it was more prevalent and frequent in the use of misclassification of employees is the construction industry. Unfortunately, it has now spread to other industries, and we feel that this bill is vitally necessary not only to protect workers in construction, but also in other places of employment. When you find that there has been intentional misclassification of a worker, you often find other violations of labor laws. This will help us identify those employers and put that issue to rest, hopefully with more enforcement. So we respectfully urge your aye vote. Thank you.
Madam Chair, members, Deanna Furman on behalf of the California Nurses Association. We too see a heavy use of independent contractors in the healthcare industry, and in this new economy we worry about the misclassification of independent contractors. We'd like to see this bill become law.
All right, thank you. Any other witnesses wishing to testify in support of the bill? Any opposition to the bill?
Thank you, Madam Chair, members. Mira Girton here on behalf of the California Chamber of Commerce in opposition to the bill. I would like to start by stating we do appreciate the author, as she expressed in the last committee, willingness to work with us to address some of our concerns that we raised there. However, due to conflicting schedules and the recess, we haven't had time to actually sit down and have those conversations yet. So as it stands, the current version of the bill, we are opposed. And also to state, we're not opposed. I think, we share a common interest and we support the goals of the author to go after businesses that cheat, legitimate businesses who are following the law, complying with the law, and doing their best to serve their employees well. So we agree with that motivation. What our current concern is that the way that the bill is written, it will capture good actors because it deals with an area of the law that is ambiguous and unclear for a lot of employers. And in some cases, despite their best efforts, they're unable to comply with the law. That is because there's two different standards currently, two different tests for determining whether an employee, a worker is an employee or an independent contractor. And even the way that those tests are applied leaves room for some doubt in the employer's mind. And so they may not find out until they've already had a ruling against them that they misclassified someone who they intended, with all intents and purposes, that they believed was an independent contractor. And this leads to the second issue of what is willful misclassification. The way that it's defined in the bill is a voluntary and intentional misclassification, but that means that you can voluntarily and intentionally believe that the worker meets the test, was properly classified, and not have any intent to evade the protections that exist in law for employees and yet still violate the provisions of the law. So for those reasons, we currently have concerns and are opposed to the bill. However, we do look forward to working with the author going forward and hopefully resolve these. Thank you.
Madam Chair, members, Chris McKaylee on behalf of the Messenger Courier Association of America as well as the California Grocers Association. Similar to our testimony in the Labor Committee, and we did have an opportunity to speak briefly with the sponsors and the author's staff, and we'll continue to work towards hopefully something that all parties could ultimately support. I sort of see the bill in three parts. The first and the third are not objectionable. The first is the willful misclassification. We're not here to defend a wrongful actor. And the third is the third-party entity that is helping to engage, if you will, in that misclassification. As to the second, it's less of a problem that the employer be mandated to provide the information. The problem is that there's no real benefit, particularly to the employer who's mandated to provide that information. For example, one of the requirements is to provide to the worker the factors used by EDD. Unfortunately, EDD historically has chosen, depending on the facts and circumstances of the particular case, to apply different factors. So how is that of benefit to either the worker or the employer in that situation? Similarly, we've had instances, numerous ones, wherein the worker and the independent contractor have a firm agreement, a written contract that specifies what are the rights and duties and responsibilities of both parties. Those have been thrown out by both the courts and the EDD as well. So even where clearly both parties knew and understood what their roles were and responsibilities, those were still ignored. I think at the very least what we would like to see is some sort of perhaps a presumption be provided to the employer. Providing the notice to the employee may not be a sufficient basis for an absolute protection from an audit 2 or 3 years down the road, but perhaps moving the burden, shifting the burden to the EDD to disprove the independent contractor relationship, because what happens again is that the employer and the individual have, again, in some instances, a written contract, and 2 or 3 or 4 years later, EDD comes in and audits and completely ignores that ignores the general factors showing right of control and find an employment situation. And it's that sort of instance that we think there ought to be something provided in statute to help both the employer and the employee in that instance. So with that, we continue to oppose, but we do continue to work with the author and the sponsor and hopefully can come to some sort of an agreement. Thank you.
Thank you. Any other witnesses wishing to speak in opposition? Senator, go ahead.
Madam Chair, I apologize for being late. Greg Cook, and I represent the Greater California Livery Association. I'm here in support of the bill. The bill is critically important to our industry. There's a whole new business model that's developing in the livery industry, encouraging the development of co-ops that hire chauffeurs from a cooperative of, quote, independent operators. It's having a devastating effect on the industry. We urge your support of the bill. Thank you.
Thank you. Any other witnesses in opposition? Senator Corbett, would you like to respond to any of the issues that were raised?
Yes, thank you, Madam Chair. First of all, we are working with the opposition on some of the concerns that they have raised. I think something that's very important for the committee to know is that if an employer is unsure, they can seek a determination from the Employment Development Department. So there's an opportunity, if you're not sure, to make sure that you're not in violation of the law, and then you can take corrective action. And then the other thing that should be emphasized once again, and I emphasized it in my statement, so I won't dwell on it, but we're in agreement with the opposition as well, where we're there and they say that they are interested in going after the bad actors as well. Everybody agrees that bad actors are the ones that we should be doing something about. So that's why this bill speaks to willful misclassification and knowingly misadvising employers. So we're really looking at those who intentionally, not those that are making an innocent mistake, but those who are intentionally violating the law or advising folks to do so. So, glad to continue working with the folks that were here testifying today, and I would just ask for your aye vote as this on this bill today.
Thank you. We'll take that as your close. Senator Leno.
Thank you, Madam Chair. With regard to this issue of willful, and I agree with you, Senator Corbett, I don't think that the opposition is that far from where you are, in that we want to keep a level playing field. We don't want a bad actor to have an advantage over a good actor. I would imagine that, as the bill is written, that in some of these gray areas, and I'm not here to say there are not gray areas, and my office has convened a few meetings and probably treacherous waters, but to try and remove some of the ambiguity, because I've heard some horror stories of employers who have really, in fact, I know some employers who even pay all of the taxes and such that one would if we were dealing with employees, even though they're not, just to cover themselves as an insurance policy, because they've been caught up in, and also EDD has created some horror stories for them as well. But that if one felt that there was an ambiguous situation, that if that employer did proceed to EDD to get some kind of determination and had that on record, even if EDD later contradicted itself, it would be hard to prove that it was other than that it was willful if you've got on file that we weren't sure. We wanted to do the right thing. We went to EDD. Now they've reversed themselves. That's their problem. But proof that the employer was not trying to get away with something.
Right. That's a perfect example of someone who's not involved in a willful act, and I believe would be able to be argued to show that there was no willful intention to violate the law, especially since on their own, voluntarily, they sought out the information from EDD.
So I only encourage you to continue your conversations.
Of
Hopefully
course.
it does get worked out. In the meantime, I move the bill.
We want it to work. Thank you.
Okay, we have a motion. I do just want to say this is a very difficult area of law to legislate in, because the definition of what is an employer and what is an independent contractor changes so much from situation to situation, industry to industry. But I do support the goal of the bill, and so I'll be voting aye. We have a motion. Call the roll.
The motion is due pass to Senate Appropriations Committee. Evans?
Aye.
Evans, aye. Harmon? No. Harmon, no. Blakesley? Corbett?
Aye.
Corbett, aye. Leno? Aye. Leno, aye.
Vote is 3-1, and the bill is out. Senator Corbett, yes, thank you. I was about to ask you if Mr. Simidian could slip in. You've been very patient, Mr. Simidian.
Thank you, Madam Chair.
So, committee members, we are on item 10, SB 558. Go ahead and proceed as soon as the noise dies down.
That's a roar of approval in the background for the bill, Madam Chair. Thank you, Madam Chair and members. I think your analysis does a nice job of laying out the issue, so I'm going to try and focus on what I think the key points are here in my opening. As the analysis says in the very first sentence, the bill would change the evidentiary standard of proof for elder independent abuse or neglect cases from clear and convincing to preponderance of the evidence. What's that about and why is it important? Some of you will recall, and the analysis references the fact that back in 2004 I authored legislation that was similar in that it changed the burden of proof from clear and convincing to preponderance of evidence for elder financial abuse. That bill had bipartisan support at the time, passed 31-1 on the Senate floor, as a matter of fact. The challenge in these cases is not unique, but certainly specific to these cases, in that when you are trying to bring a case and make justice happen and also provide a reasonable deterrent to the kind of behavior we're trying to address here, you face a combination of circumstances, if the standard is clear and convincing, that doesn't typically exist. That combination of circumstances is that the victim himself or herself is very unlikely to be able to fend for themselves, to communicate thoroughly. They are, by definition, the most vulnerable among us and ill-equipped to speak on their own behalf when a case is brought. Secondarily, it is the nature of these cases that there are typically very few witnesses available. And then third and finally, when there are witnesses available, particularly if it's in an institutional setting, the witnesses who are available are ordinarily employees of an institution who are understandably reluctant to put their jobs and their livelihoods at risk, testifying either against the institution that employs them or a coworker. For all of those reasons, these cases are therefore very difficult to bring under the existing burden of proof that both denies folks justice who deserve it, and it also means that the law does not serve as significant a deterrent as we would like. That was the thinking behind the bill that I authored in 2004 on financial abuse. I think it is arguable, actually, that the case is even stronger with respect to physical abuse, with respect to the vulnerabilities and the difficulty of obtaining witnesses. That is the bill. We have witnesses. I would respectfully ask for an aye vote.
Thank you. Witnesses in support?
Good afternoon. Neil McCarthy with the Consumer Attorneys of California. I practice in the area of financial elder abuse as well as neglect cases. As the committee is aware, the California Elder Abuse Act protects all senior citizens of this state, regardless of the type of harm, whether it's a financial harm or a physical harm. And right now in the law, we have a very unique disparity where in a financial abuse case, a senior citizen has a burden of proof which is lower, preponderance of the evidence, than in a typical neglect or nursing home case. And the net result is you could have a situation where a grandmother gets cheated in a real estate scam, has a much easier time of getting her money back than a grandmother who gets beaten up in a nursing home. And it's a situation we like to see remedied. And frankly, the disparity makes no sense given some of the points the Senator just said, which is in the typical nursing home case, the proof is much harder because the only witness is often the senior citizen who in many cases is unable to testify. One final point, which is in the opposition papers, there's a suggestion that, well, if you pass this law, a simple negligence case is going to subject nursing homes to increased litigation and increased attorney's fees, and that's simply not the case. There's an additional layer of protection that's in the current law that was not changed, which is in a nursing home case, a plaintiff must prove, in addition to neglect, recklessness, malice, oppression, or fraud. So again, there's an additional layer of protection in a neglect or physical abuse case that is not present in a financial abuse case. But what this bill would do would give senior citizens equal footing, or at least much closer to equal footing under the law, and we request an aye vote. Thank you.
And thank you. I'm Prescott Cole. I'm Senior Staff Attorney with CANNER, California Advocates for Nursing Home Reform. I've been with CANNER for the last 16 years, and part of my job is to talk with family members and the victims themselves of abuse or neglect in nursing homes. And certainly, over these years, I've heard from thousands and thousands of people. What is the extent of the problem? Certainly not every call will end up in an official complaint, and certainly not every complaint will end up in a lawsuit. I just want to read very quickly the state ombudsman, statewide annual data from the ombudsman. What is the extent of the problem? In the year 2009-2010, 1 year period, they had 1,877 cases of physical abuse, which included corporal punishment, 560 cases of staff sexual abuse, and 803 cases that they class as gross neglect. Now, with these cases, these are non-economic damages because these people who are in the facilities, they don't work, often they're aged, and they have nothing else going for them in the way of damages except pain and suffering. Every elder abuse case is a pain and suffering case, and it's also about the egregious conduct of the caregiver, because that is what you have to build by the way of showing evidence. You have to show that there was injury. You have to show intentional, reckless conduct on the part of the caregiver. And then for the employer, you have to show advanced knowledge, conscious disregard, which is that they knew, they should have known, or they ratified the conduct of the caregiver. So if we are looking at this bill as really changing the dynamics of these cases, that's not what we're doing. You will have to prove everything in this case. You'll have to have evidence that shows injury, conduct, and advanced knowledge of the employer. The only difference is we will be showing, if this bill passes, this evidence by preponderance of evidence, not clear and convincing evidence. We have to go through everything, all this intricacy, the same way. It's just we are lowering the standard of care. Preponderance is what is normally used in all other cases for personal injury cases. That's wrongful death cases. That's somebody who's drunk that goes through a stoplight. That's the doctor who unfortunately cuts off the wrong leg. In these cases, you have witnesses. In the cases that we're talking about, the witnesses are controlled by the facilities. The records are controlled by the facilities. We are saying that the true victims here that we're trying to protect are the individuals in the facilities. And we are only asking for fairness because at the end of the day, you will still have to prove for an ADACPA case, you'll have to prove egregious conduct, and you'll have to prove pain and suffering. We urge an aye vote.
Hello. My name is Dennis Haney, and I was asked to come down here today, and I thank you for the opportunity to be able to speak to you. My mother, Doris Hilton, died as a result of neglect and not being taken care of. I went to 4 different homes to find an adequate home to put her into. My wife had a heart attack, and we couldn't keep her at home anymore, and I couldn't take care of both of them. So I went to Eschaton, and I put her in Eschaton. They lost her teeth. They let her get dehydrated. She had an infection, and they treated her for 4 days for the infection. They had a 90-day hearing, which I went down to, and I asked them to bring them down. And they didn't want to bring her down to the hearing, but they finally did. And at that hearing, she was slumped over in her wheelchair. And I told them then that she had the infection and to have the doctor come back and to treat her for it. And they didn't do it. They called me 4 days later and told me that my mother was in a coma and asked me what to do with her. And they had all the directions in her file to know what to do with her. And I had her send her to Kaiser. They put her in an ambulance and took her to Kaiser in Roseville. I went to Kaiser in Roseville, and the doctor told me at the time that she would not live. And I sat with her for about 3.5 days while she passed away. Had she been adequately taken care of and had the people who were in charge of taking care of her had the proper education to do the job, she would be alive and she'd be here today. And she's not here today. I'm not a lawyer. I'm a contractor. If there's anything we can do to protect our senior citizens, then we need to do it. And I thank you for the opportunity to be here. Thank you.
Thank you, Madam Chair and members. Kathy Sunderling with the County Welfare Directors Association, representing the Adult Protective Services programs in all 58 counties in support of the legislation. We think it makes a lot of sense to have the same standard here as with the financial abuse to ensure that these cases can be brought. Thanks.
Thank you. Any other witnesses in support of the bill? Since we've had several witnesses already, please try to limit your testimony to your name and affiliation and put your support on record.
Madam Chair, Darrell Kelch with the California Association of Area Agencies on Aging. We're in support of the bill.
Henny Kelly, on behalf of California Alliance for Retired Americans, we are very proud to be a sponsor of this bill, and on behalf of our 900,000 members, many of whom are in nursing homes, we really support this bill and ask for your aye vote.
Mike Montgomery with the Congress of California Seniors. We support the bill.
Thank you very much. Any witnesses in opposition to the bill?
Good afternoon, Madam Chair, members. Dave Helmsen on behalf of the California Association of Health Facilities. Start out by appreciating Senator Simitian's longstanding and genuine interest in this area and the work that he's done prior. Today, it's an interesting discussion. I mean, this bill isn't limited to nursing homes by any means, but I think we've become the poster child for today's discussion. And I find that rather ironic, given that in comparison to other venues, we have far more securities in place to protect our residents and work every day to do just that. We have background checks for every employee. They're all mandated reporters. We have licensing boards, registries. We have training, including DOJ videos with handcuffs and guns, mandated for every single employee. We've got a steady stream of non-facility people in the building, nurses, doctors, therapists, family. We've got an enormous amount of oversight in those facilities. I mean, Department of Public Health alone has over 1,000 people doing nursing home oversight. They come not just with people, but they come with remedies that consist of penalties of every denomination as well as other sanctions. So from our perspective, while we might be the most attractive for litigation in this regard, we're probably arguably the safest place for an elder-dependent adult to be. We're concerned about this bill because we think it encourages a trend that's basically classifies virtually everything that happens in our facilities that's an unwanted outcome as abuse and neglect. And some of the testimony grouping the numbers we heard, those aren't numbers about cases. They're numbers about allegations, suspicion. They're numbers about breakdowns that may be deficiencies, but for convenience, they're all lumped into elder abuse and neglect. We understand the purpose of the bill to be to attract attorneys or to get attorneys more involved in these cases. In some of the literature we've read, we find that interesting in that there's a burgeoning group of these attorneys that are specializing, soliciting, and pursuing these with vigor as a lucrative business practice. About ensuring quality, the litigation piece of quality, studies have shown has no bearing. If you look at quality measures, good facilities, quote, get sued just as often as bad facilities. The cases that don't seem to be there are surprising to me. National studies show that California leads the nation in number of cases, amount of judgment in nursing homes, as well as the price per bed, which is of concern to the facilities. We're spending about over 3.5% of all our costs are into litigation and liability. So in summary, I think the bill may be good for attorneys, and we certainly don't want to deprive anyone of due justice here. But until we have a clear defining line between what is really abuse and neglect versus what is a mistake, poor judgment, or some other procedural error on the part of a well-intended facility, we think that the threshold that we have in current law is critical to not letting these statutes be used in a way that wasn't intended when they were constructed. So unless we can get that addressed, we must remain opposed to the bill. Thank you.
Good afternoon.
My name is Kippy Roten, and I am a defense attorney, and I specialize in the representation of long-term health care providers, professionals, in most instances where they have been accused of neglect and abuse. And I do want to say, before we talk about where I'm in opposition to this bill, I think that it's important for us to get to a point of where we're all in agreement. Please do not take anything that I say to be construed to suggest that in any regards elder abuse is tolerable. It is not. And that is not what we're here to discuss. We're here to discuss an equally important requirement which our government has a responsibility to shepherd, and that is to assure that there is an even balancing of the requirements of the law such that the citizens that are being held accountable are being told exactly the character of the conduct to which they're being held accountable, and they are given a clearly defined law that actually gives them notice of how to behave, and more importantly, gives our jurisprudence, our judges and our civil juries enough information so that they make appropriate decisions that are absent of capriciousness or arbitrariness. And when we take a look at the due process question of this bill, and certainly listening to highly emotional stories, which are very compelling to me as a human being, it is important for this very esteemed committee to understand that it is in the face of such emotion and such concern over a vulnerable population that demands that we are very strict in our guarding of the due process rights of particularly a potentially unpopular defendant. And historically, our jurisprudence has demanded, any time we have ratcheted up the types of damages and remedies that are available, that we have also ratcheted up alongside, in lockstep, the level of scrutiny required before you can establish such conduct. Because we're talking about branding individuals as being abusers, and there's nothing more incredulous that an individual would have to live with than being branded with such a title. Over the past 20 years, since the initial passage of the Elder Abuse and Dependent Adult Civil Protection Act, which does follow in line with traditional jurisprudence due process, lockstep, increased severity for the damage that is going to be assessed for the increased severity of conduct, of misconduct. That is going to be eliminated by this bill, and I have given to you a document that I think is about the clearest way I can define to you what actually occurs in a court of law. The concern, first off, has been that the clear and convincing standard creates an insurmountable hurdle. Unfortunately, while a clear and convincing standard was initially deemed to be something that was going to be rigorous, today it is not so. The difference in title between clear and convincing evidence and that for negligence is more likely to be true than not true. Clear and convincing evidence is a standard that is more likely to be true. If we apply the present standards to the actual jury instructions that are read in California courtrooms today, up and down the state, that were adopted by the Judicial Commission of California and our standard jury instructions, here are the definitions that are read to our juries today. These are distinctions without any difference. Negligence is the plaintiff has established that it is more likely true than not true. I'm sorry.
I'm going to have you wrap up your testimony. And honestly, you don't need to read me the jury instructions. I've spent 20 years in civil litigation, so
I appreciate it. Then let me
read to me.
Then let me finish with.
Just wrap it up, please.
Let me finish with a statement that more likely true than not true that a reasonable standard has or has not been met is contained within each of these definitions. Yet within each of these definitions, a finding of arbitrariness is allowed to our juries where they can come to a conclusion for heightened remedies that are allowing for the most stringent penalties in our state in the civil arena. And for that reason, I believe that due process requires that before we take a look at altering the language of the Elder Abuse and Dependent Adult Civil Protection Act, that we take a serious examination of balancing what is going to actually occur in the courtrooms to be sure we're accomplishing that which we're seeking. Thank you.
Madam Chair, members, Catherine Pettibone with the Civil Justice Association. We are in opposition to this. Most of the colleagues have covered the issues. We are afraid that this is going to result in increased litigation against medical professionals, as that we believe it might be an end run around MICRA. A recent article, 2007 article, Los Angeles Lawyer, as well as a 2010 Law Review article, noted that courts are continuing to struggle with the distinction between neglect and professional negligence. And it also noted that reckless neglect in these cases has become the favorite and most frequently type of elder abuse case brought. I know our time's limited, so I'll just wrap it up. Anyways, for these reasons, we oppose.
Appreciate the brevity of your comments. Thank you. Go ahead.
Thank you. Mira Girton here on behalf of the California Chamber of Commerce, also in opposition for the reasons previously stated, in particular the concerns about this potentially being an end run around MICRA. Thank you.
And I do want you to know I've read all of the letters in opposition. Go ahead.
Pat Blaisdell from the California Hospital Association. For all the reasons previously stated, we're also in opposition to this bill.
Any other witnesses in opposition to the bill? Senator Simitian, would you like to respond to some of the issues raised by the opposition?
I would. I would like to say first, let's refocus on the issue before the committee, Madam Chair. The bill has nothing to do with MICRA, does not amend MICRA. I know that that's a topic that suddenly raises eyebrows and generates concern, but it's not the topic on the table before the committee today. And I'm going to go a little off script, Madam Chair. Some of the witnesses took some shots at nursing homes. Some of the witnesses took some shots at lawyers. That's not a very productive conversation, in my view. I want to refocus the conversation on the folks that we say we're trying to protect. I want to go back to where we started. As the gentleman from Cantor mentioned, preponderance is the typical standard. Preponderance is the standard that applies to financial abuse. All of the elements still have to be proven. The question is there some reason why it should be clear and convincing in these abuse and neglect cases? And the great irony is, if ever there was a place where the argument can and should be made that it's the wrong place for clear and convincing and the right place for preponderance, it's these cases for the reasons I mentioned earlier. Victims who are unable to fend for themselves after the fact, an absence of witnesses, and the witnesses who are available are frankly in a very difficult situation in terms of their ability to come forth without putting their livelihood at risk. The goal in the law is twofold: to provide a significant deterrent and protect people, and to provide some measure of justice when the deterrent has failed and they have been wronged. Both of those goals will be better met if we have an aye vote on the bill today. I respectfully ask for an aye vote.
Senator Simitian, I wanted to be clear. Are you taking the amendments?
Taking committee amendments.
Okay,
thank you for your staff's work in getting us to dot our I's and cross our T's. It's important. Thank you.
Good. These amendments will clarify that the standard of proof for punitive damages is not changed.
That's correct.
Okay. Yes. Senator Corbett.
I have a question. Is there any proof that changing the standard will have any impact on liability insurance and the cost of that insurance?
Not to my knowledge.
And do we see that experience in any other area of the law?
Well, the only thing I can tell you is, this is going to seem an odd response through the chair. I did an elder abuse with Senator Wolk that requires banks and credit unions to be mandatory reporters when they see financial abuse. And at the time, the banks and the credit unions were very worried that there was going to be some adverse consequence in terms of their own liability issues. And there was a sunset provision that was put in the bill back in, I think, 2006. And sure enough, 5 years later, those concerns have proved to be without basis. And to their credit, The banks just put an op-ed in the Mercury News saying, we support the elimination of the sunset. The concerns that we have not proved to be real. We had similar arguments raised when we changed the standard of proof for the elder financial abuse, and people were concerned that somehow there'd be some explosion of litigation around financial abuse issues. Hasn't happened in the 6 years now since that bill was passed and signed into law. I hear the same arguments again that I've heard in the past. I don't see evidence that persuades me that that's the case, and I think history suggests that those concerns are frankly without basis. I understand that they're there. All of us are anxious about change when it happens, but I think we've got a pretty good track record that, in fact, that's not the basis for legitimate concern.
Thank you, Senator Simitian.
All right, we have a motion. Clerk will call the roll.
The motion is due pass as amended to the Senate floor. Evans?
Aye.
Evans, aye. Harmon? Harmon, no. Blakesley? Blakesley, no. Corbett? Corbett, aye. Leno? Leno, aye.
Vote is 3-2. The bill is out. Thank you, Senator Simitian. Senator Wolk, I thought I saw you. All right. Item 12 on our agenda, SB 595.
Madam Chair, I'm handing out some pictures of abandoned vessels in the Delta for all of you to take a look at, so you have a sense of what we're trying to do here. I'm certainly taking the author's amendments pursuant to Section 6 of the committee's analysis to clarify the 30-day notice provision for abandoned vessels. This is a reintroduction of a bill which I authored in 2009 and was passed by this committee. This bill enables the State Lands Commission to take administrative action to remove vessels illegally stored on state lands and vessels that pose an immediate threat